Hello again, dear students. This is another lecture number 4 of our module, which is entitled Fight Against Corruption at Criminal Law Department of Baku State University, our spring session of 2020, a module for the postgraduates. So, in our previous lecture, we spoke about the dynamics of development of the concept of corruption, and according to this concept of corruption, we followed the anti-corruption efforts and their strategic planning in Azerbaijan. So, in order to set you a general framework of our conversation, for you to imagine in a wider perspective how it's operating. Fight against corruption in Azerbaijan, the same goes for any other country. It shall have necessary components. Without these necessary components, it will be difficult to achieve any sort of result in the fight against corruption. And the same goes for different type of activities. Unless you have everything planned well in advance, everything coordinated, the specialized bodies appointed in charge of these measures, you will not be able to bring about any result. So if we look at the fight against corruption in Azerbaijan, we'll see that the necessary elements are strong political will, adequate regulatory framework, operative specialized agency, and transparent public governance. We're not going to speak about all these three elements, such as strong political will, adequate regulatory framework, or transparent public governance today. Today we're going to limit ourselves exclusively to the operative specialized agencies. So what can we say about these specialized anti-corruption agencies? We can speak about these agencies in a very specific, in a very narrow manner, and we can speak about quite in a wide range. If we speak in a narrow manner, of course, we will speak about what the United Nations Convention Against Corruption gives us as a model. According to this model provided by the United Nations Convention, and we know that Azerbaijan took on this model after it ratified this convention in 2005, and you know well that this convention also became effective in the same year. Azerbaijan accepted it as a general framework, and in many other capacities, which we will go back again and again to this document and mention that it is a part of the Azerbaijani legislative system, it's part of the Azerbaijani laws. More importantly, we will mention at some point that Azerbaijan accepted this document as a ground for legal cooperation and extradition and mutual legal assistance with other states with which we don't have any treaty. But so far as it concerns our today's topic, according to anti-corruption, this United Nations Convention Against Corruption, there should be 2 specialized anti-corruption agencies, and we will look at that in detail later on. These agencies are: number 1, Agency for the Prevention and Strategic Planning of Fight Against Corruption, and 2nd, Law Enforcement Agency to Fight Against Corruption. Please note that specifically that United Nations Convention, neither this document, neither this instrument, nor any other instrument, international convention, or no other international institution requires that there shall be present specialized anti-corruption agencies. However, it is the best practice, it is considered to be the best practice by international expert community that law enforcement agencies as well as strategic and planning agencies shall be specialized in the fight against corruption. According to the ANCAC, there could be not one but several institutions operating in many areas. So instead of having, for example, one agency in the field of prevention of corruption, there could be 2 or even 3 agencies working and operating in a coordinated manner so that they deliver upon the task which is posed to them. But the general position, the main position taken by the international expert community is that there should be one agency, one in the field of prevention of corruption and one in the field of law enforcement. However, in many cases, even these functions are taken together. I won't put it on my presentation. I will just mention it to you that there are examples of countries where there are no specific specialized anti-corruption agencies. An example would be a country of Sweden. In this country, we know that Sweden has one of the most developed bureaucracies in the world, and when I say bureaucracy, I don't mean it in a negative meaning. No, the state agencies, the public institutions of this country are well established with good channels of communication, good mechanisms of cooperation, so they have a mechanism of setting up tasks and securing its proper communication, development of a single policy, and subsequently implementation of this policy. So if any task comes up, as for example fight against corruption, this state administration system, these channels of communication in Sweden, they come into play and they successfully take on this task, they digest it, ensuring the intensive communication between state institutions, development of a single policy and then institutional policies, and so they deliver well, and therefore there is no necessity to develop a separate parallel system of specialized anti-corruption agencies. There are countries which have, as I said, combined these 2 functions of prevention and law enforcement together. The experience of these countries, the history of the countries which are close to Azerbaijan, we share to a certain degree some traditions of the past, perhaps to some degree mentality. These are the countries of Baltic region, and the example would be the Special Investigation Agency STT of Lithuania, or the KNAP of Latvia, and so on and so on. These agencies, they combine these functions together. Another excellent example will be ICAC of Singapore, or the Specialized Anti-Corruption Agencies of Hong Kong and Singapore. They managed to combine these 2 functions, even 3 or 4 functions together, but principal are to prevention and criminal investigation and prosecution. So when we speak about Azerbaijan's experience, these specialized anti-corruption agencies in this country are Commission on Combating Corruption, which is the specialized, according to the ANCAC model, it's a specialized agency in the field of corruption prevention and strategic planning. And then comes, you see the Azerbaijani abbreviation for it, KMBI, which is Anti-Corruption Directorate. We say it in English. In Azerbaijani, it's Korrupsiya Qarşı Mübarizə Baş İdarəsi. So this agency is a specialized anti-corruption agency in the field of law enforcement. And as you know, perhaps you know not, the concept of law enforcement differs from country to country. When we say law enforcement, we purport investigation and special investigation means. So Anti-Corruption Directorate is an agency specialized in this field. So far about the specialized anti-corruption agencies in the narrow sense. When it comes to the wider sense, it's worth remembering the provision of the Azerbaijani legislation, specifically Anti-Corruption Act 2004, which became effective as of 1st January 2005. You remember that it states in Article 4 that it is an obligation and duty of all our public institutions and public officials to fight against corruption. Of course, we understand that this, the same as this act is considered a framework act, this, in a similar manner we say that it's a kind of a declaratory provision, but it's still a piece of our legislation which we have to count with. In that sense, all the state agencies and all public officials in this country could be considered as institutions and people entrusted and commissioned with fight against corruption. However, if we narrow down a bit this circle of agencies fighting against corruption, we can tell that there are specific bodies which are directly contributing to the areas which can be considered as areas of priority in the fight against corruption. And of course, the champion, the very known champion in this field would be the well-known agency, a kind of service provided by state agency entitled ASAN. And the recently appearing agency of a similar type in the field of social security, DOST. Another agency which can be directly linked and considered a specialized anti-corruption agency in Azerbaijan is Civil Service Authority. The reason why I put its name in a more generalized way is that as a result of recent institutional reforms, before these institutional reforms, there used to be a special state commission on civil service, and then as a result of this reform, it became part of the state examination institution, which is the Public Law Agency. Of course, we're not going to discuss here the rationale of this institutional reform, but before this institutional reform, this agency used to be, the Civil Service Authority used to be more visible, and I would say more active, and it played crucial role. I mean, don't take me wrong, its activity, it's still very important. It's crucial in building the proper civil service in Azerbaijan. However, as a result of this reform, this agency kind of moved behind the scenes. It's not so visible as it used to be, but hopefully we'll see more of that. We'll mention about the work of this authority. It operates within another institution now, but it's still a key, it's still instrumental in the fight against corruption. Finally, the final element which we have to put in this chain of anti-corruption agencies, specialized agencies, are the internal units, internal security units. Please note that this concept, it became a part of the public agenda in the course of the implementation of state anti-corruption strategy on increasing transparency and fight against corruption for the years 2007 to 2011. And subsequently, it was a subject of the subsequent strategies and action plans in the field of fight against corruption. The rationale behind this is that each state agency which operates on a national level, which were also called otherwise in Azerbaijan as central executive authority, whether it's in the format of a ministry or committee or service, it is supposed to have internal unit. This internal unit shall take charge of the issues of suppressing corruption within that institution, and we'll speak about it in more details later. But for now, we're moving to this concept of a specialized anti-corruption agency, first in a narrow sense by looking at so-called, using the terminology of United Nations Convention Against Corruption, preventive anti-corruption body or bodies. By the way, I'm taking on your previous remarks about remarks on how we can improve these lectures, online lectures. I know it's new for you and it's new for me too, so we will try to ameliorate and improve the quality of these conversations. I slowed down the pace of this lecture, and I also promise that I will be making pauses between the ideas which I'm conveying to you, so that you have time to stop and switch to a new coming thought. So it's in front of you, Article 6 of UNCAC, United Nations Convention Against Corruption, entitled Preventive Anti-Corruption Body, which says, and I will read it out for you, each state party shall, in accordance with the fundamental principles of its legal system, these are the kind of words which are repeated in many articles of this convention. Now we come to the main part. Ensure the existence of a body or bodies as appropriate that prevent corruption by such means. It is the same idea which I told you a couple of minutes before, that it's up to the state to decide whether it will be one institution or many institutions. So the charges, these institutions, one body or several bodies, they shall be charged with, first of all, implementing the policies of which I spoke in great details to you in our previous lecture. This policy shall be operating as a general framework for all anti-corruption initiatives in the country. Another task which is prescribed, which has to be performed by this preventive anti-corruption body or bodies, is the task of increasing and disseminating knowledge about prevention of corruption. We'll go to this in details later on, but for now I can tell you that it's the main task of this, one of the main tasks of this institution shall be raising of public awareness. We know that it's one of the best means to fight against corruption, to alert people about the dangers and risks of corruption, as well as the measures how to avoid this kind of dangers and risks. What kind of requirements are posed to these institutions? I mean, in speaking in simple language, what kind of qualities these institutions they have to have in order to be effective in the fight against corruption. First of all, they have to be independent, and they, as you see here, and they have to carry out their functions effectively and free from undue influence. So this magic word independence. One thing which we have to remember at all times is that there can't be an absolute independence. The institutions, we know that institution is an abstract concept, but also the people who operate in that institutions, they don't live in a vacuum, as none of us do. They have to have some sort of relations, and in these relations, they have to achieve the maximum level of independence that they can possibly have. So when we say independent, of course we don't say that it shall have its own army, its own police, or its own services. No, but it has to operate in such a way that it's effective, that no other relations, none of its links, none of the atmosphere where it's actually operating, it undermines its efficiency in the first place, as you see from the slide, and nothing makes it operating under undue influence. This magic word, as you see, undue. There shall be influence, of course, the same logic as was used in terms of independence, the same logic applies in terms of influence. There should be some influence anyway, and it's totally unavoidable. The institutions, they cannot avoid influence completely. The main issue here is that this influence shall not be undue. Whatever makes people think that the influence is undue, it actually undermines it undermines the independence of these institutions. Later on, we'll also accentuate on two important issues that they have to have a specialized, as you see here, staff for which training is required, and they shall have necessary material resources. So in order to be independent and carry out their functions effectively, they shall be free from undue influence. All the necessary legislative and institutional measures has to be taken to secure this, and they have to be provided with sufficient material resources, which means that they have to have independent budget which no one can interfere with, and they have to have a specialized staff. They have to recruit good staff and secure its specialization through continuous training. That's a general framework. Now we're moving to the specialized, first specialized anti-corruption agency in Azerbaijan, which is called Commission on Combating Corruption, CCC or COCOCO, whatever it's convenient for you to remember it. It was established on the 3rd of March of 2004. As I usually mention to you, it's not important at all to remember this date, which I, by the way, put with a mistake of the name of the March of the month with a small letter, and it has to be uppercase, as you know. Apologies for that. This anti-corruption agency, this CCC, is composed of 15 members. We'll look at that later. It's a statutory body. It's established by the statute, by law. It's composed of commissioned officers and has a permanent secretariat. What does it mean? It means that it's not in itself a continuously, permanently operating institution. No. It convenes its members to make important decisions, and its members are ex officio members. That means that other state institutions, they commission their representatives to come and sit at the sessions of Commission on Combating Corruption. Therefore, it's written here, as you see, commissioned officers, plus, but in order to secure the continuing operation, ongoing nature of the business of this institution, it has to have permanent secretariat. So it has one executive secretary and his staff, which prepare documents for the sessions, ordinary and extraordinary sessions of this commission. It was first, it's mentioned because I told you that it is a statutory institution. It is mentioned in the Anti-Corruption Act 2004 in 4.2 paragraph 2 that the functions of a specialized body in the field of prevention of corruption shall be discharged by the Commission on Combating Corruption of the Republic of Azerbaijan. It also, this act vests certain other functions, specifically asset declaration with this institution, but we'll speak about that in a minute. Before that, I would like to mention that the charter, the document which contains the terms of reference of this institution, of this body, we cannot call it institution perhaps, because it's a commissioned institution, it's a commissioned body. Its charter, the Charter of Commission on Combating Corruption, was endorsed by the Act, the Statute of, as you see, on the 3rd of May 2005. Let's briefly look at the functions of this institution. It formulates the state policy, which we spoke in details a lot in our previous lecture. It formulates action plans and state strategies in the field of fight against corruption. To this end, it uses its working group, which I will mention later, and it operates it not only formulates these state institutions, these state policies, but it also coordinates the activities of public institutions in this area. It actually collects information on the implementation of these strategies and action plans, specifically action plans. It also promotes the development of the institutional anti-corruption action plans, i.e. Each institution, central executive authority, and some other institutions, such as the General Prosecutor's Office, which is not an executive body, they have to have their own institutional anti-corruption agencies. And the Commission actually coordinates the development and implementation. It also supervises and monitors, as you see, and analyzes the work or the implementation of these national anti-corruption plans and institutional anti-corruption plans. It also analyzes the situation, the state of affairs in the field of fight against corruption in Azerbaijan and in each institution. Here you can see the financial declarations, asset declarations, envisaged in the section of the Anti-Corruption Act. It's an institution which is vested with the powers to collect asset declarations, specifically as it mentioned in the legislation, the declarations containing financial information, including assets and debts of public officials of certain category. We can tell for the purpose of this lecture that these are usually the high-ranking public officials. They are the ministers, head of state, head of the government, all MPs, all the judges and high-ranking judges and prosecutors in this country. They have to submit their declarations to the Commission on Combating Corruption. However, this function, for now, it's not operational because there's no actually operating system for financial declarations by public officials in Azerbaijan yet. The necessary framework have been elaborated, but there's certain bits and bolts which have to be implemented in order to make this operational. And as soon as it becomes operational, it's envisaged that the Commission on Combating Corruption will start to take charge of reviewing this and controlling these asset declarations. Again, I use this word asset declaration because it's a kind of established terminology in the international community. I think there would be a special section or special unit under the Commission which will take charge of this function. Also, Commission has a function of collecting analysis and summarizing of information related to the corruption violations. And what I mean here is, for years now, this Commission, it attempts to collect information and analyze from all state institutions. First of all, we speak about the corruption violations of all sorts. It's not only about the criminal infractions, criminal offenses, which the other specialized anti-corruption agency, the Anti-Corruption Directorate, provides to the Commission, but it also is trying to build a system according to which, using this system, all the public institutions, through their internal security units, they're collecting information on corruption violations, and they will provide this kind of information to the Commission. Of course, this work is done at the moment, but the national system of building up the comprehensive system is still underway. And given the fact that Commission on Combating Corruption is in such an advantageous position to collect this information from many stakeholders, and as I will mention it later, it also interacting closely with non-state actors as well, it develops the proposal on the improvement of anti-corruption initiatives, anti-corruption efforts, measures, and these proposals are specifically targeting public institutions and public officials. And finally, the function which I want to mention, the final function, is the cooperation with public and other institutions in the field of combating corruption. And when I say that, this kind of cooperation is quite multifaceted. The Commission, for example, is part of the information network of anti-corruption non-governmental organizations. So it's partnering with non-governmental organizations, NGOs operating in the field of fight against corruption. It provides information, collects information from them. It exchanges information with NGOs, civil society and other actors. It provides financial contribution, financial aid to the civil society organizations to run certain type of anti-corruption activities, as surveys, as different initiatives. If we look at the competencies and powers of Commission on Combating Corruption, we can see that it is entitled to study application and enforcement of the anti-corruption legislation. What this mean in practice is that whichever anti-corruption legislation there are and state institutions are implementing this anti-corruption legislation, they are providing their quarterly and annual reports, half-a-year reports, and yearly reports on the implementation of this legislation. Commission is very active in collecting information and materials in all related to fight against corruption. It conducts its own survey. It commissions survey with other institutions, as you will see in this row. It also collects the information through different type of sources, hotlines provided, hotline informations collected by other institutions, and so on and so on. And also one of the main sources of information, as you know, is the implementation of the action plans. And it is entitled to write inscriptions and recommendations and proposals to how to increase the efficiency of fight against corruption. And we come to the very important, very crucial competence of the Commission about the raising of awareness. We'll speak about this function in greater details in our subsequent lectures and talks, but for now I will tell you that awareness raising, as also the same as the education, is considered as one of the most efficient tools to prevent corruption. Raising awareness of people, usually when we mention this function, this competence, people start thinking about posters, about these billboards of fight against corruption, then these trailers, social trailers on TV, but it's actually wider than that. It's much wider than that. When we say raising awareness, it's making people aware, making people knowledgeable, making people understanding what kind of risks there are, what kind of dangers corruption poses to people in their everyday life. And it's not only important to make them knowledgeable about the existing corruption, about the potential risks and dangers. It's even more important to arm people, to make them stronger, to make them understand that they can resist corruption, that they can report corruption, and that corruption, once it's known to the authorities, the instances of corruption, that it will be handled and taken care of. And in order to make this function, competence more effective, the work, the efforts they have to be based on surveys, on studies, which they can't be sporadic, they have to be collected and developed on a scientific base. So as you see, the Commission on Combating Corruption, it cooperates with civil society organizations, with mass media, with private sector representatives. It's important to include this. It includes in its work independent experts, and in case if it's necessary, it involves them in the execution of certain tasks. It also cooperates internationally. It also has a competence of receiving complaints directly from people, and it also can refer these complaints to institutions and request the information on the consideration and review of these complaints, and then it gets back to the citizens. It can also commission the audit bodies to conduct certain examinations and reviews of areas of its concern, i.e. the areas which raise the concern of Commission according to information which it collects and according to the result of this of the work of these audit institutions. It can take subsequently measures, provide proposals, and request the adoption of some disciplinary measures. Finally, as we see, it's a development of anti-corruption programs. I will switch now to the structure of the Commission on Combating Corruption. It is composed of 15 members. Five of these members are nominated by Parliament, Milli Majlis. 5 members are nominated by a legislative branch of power. 5 members are nominated by the executive, i.e. the president, and 5 members are nominated, are appointed actually by a judicial branch. In this case, it is the Constitutional Court of the Republic of Azerbaijan which make appointments on behalf of the judicial branch. And I should say that, for example, the Prosecutor General of the Republic of Azerbaijan is a member of the CCC, and he was appointed by the judicial branch. Head of the Judicial Legal Council, Mahkeme Hukuk Şurası of the Republic of Azerbaijan, was also appointed by the President of the Constitutional Court on behalf of the judicial branch, and also the Chairman of the Azerbaijani Bar Association is also a member of this commission. From among its members, the commission elects its own president, and currently the president of this body is the head of the presidential administration. Please note, students, that Commission on Combating Corruption does not belong to any branch of power. It simply can't belong to any branch of power, since it's a kind of consortium based on the agreement between different branches of powers. So when I ask you the question, or anyone else asks you a question, which branch of power it belongs to, you should know that it doesn't belong to any branch of power. It's an independent institution, as independent as it could be. It has many working groups in order to facilitate its work, and one of the leading working groups is the Working Group on the Improvement of Legislation, which actually developed the text of all these anti-corruption strategies, the drafts of anti-corruption strategies and anti-corruption action plans. That's it about the prevention specialized anti-corruption agency. Now we switch to the specialized anti-corruption authority in the field of law enforcement. According to Article 36 of the United Nations Convention Against Corruption, Article 36 provides for the law enforcement specialized agency. According to this article, there should be a body or bodies or persons specialized in combating corruption through law enforcement. With the same logic as we applied to the prevention institution, states can have one or several institutions, or indeed they can have a unit in a law enforcement agency which can be specialized in the field of fight against corruption, or There could be an agency specialized in other fields, like for example anti-fraud agency, like the case in the UK where they have this serious fraud office, a specialized prosecution service, which among others is also specialized in handling high profile corruption cases. So the model is to be chosen by the state according to its legal tradition, but the international legal community, it encourages the states to actually establish such a body or commission a body with this function, make it specialized in the field of fight against corruption. It has to have this necessary independence. Again, it's absolutely impossible to be absolutely independent, but the authorities, they have to secure the necessary degree of independence. And I will speak to you on the example of Azerbaijan, how this independence is secured, and it has to carry out its functions effectively and without any undue influence. It has to have proper staff. It has to be provided with necessary resources and training to carry out its tasks. In Azerbaijan, it's an anti-corruption directorate, KMBI, with the abbreviation which we use also in international reports. This is the fantastic building of this directorate. Why did I put this image of the building? Because it's one of the attributes of its independence. It shows the government through its statements, through its expression of political will, and through providing of necessary resources, it shows that this institution is independent. I mean, it contributes to the independence of the institution. KMBI, it's with the Prosecutor General of the Republic of Azerbaijan. It's reflected in its official title that it's with the Prosecutor General. What does it mean in practice? Is that it's not part of the General Prosecutor's Office, which is the main headquarters of the prosecution service in Azerbaijan. It's a specialized and a kind of autonomous anti-corruption prosecution service, apart from being a specialized anti-corruption national agency. It's similar to, let's say, a military prosecutor's office. Its independence is secured in several ways. As I mentioned, it's an autonomous anti-corruption prosecution service. What does it mean? It means that its head, the head of the KMBI, of the Anti-Corruption Directorate, is ex officio, I mean by his post. He is also the deputy to the Prosecutor General. So all the communication between the prosecution service is conducted through the director of the KMBA. So the other structural units of other prosecution services, they cannot supervise or intervene with the work of the Anti-Corruption Directorate. Here unfortunately, I forgot to change. It's not department, it's higher than that. It used to be department until not so long ago, but as a result of reforms, its status was elevated, so now it's directorate. And the structure of the KMBI is, it has 7 separate units. It has organization and IT department, which is actually organizing the work of this institution. It can be called institution, and it actually conducts the analysis and strategic survey of the activity of this directorate. Another unit is Prevention and Inquiry Department. This unit is actually the unit which is entitled to carry out, apart from law enforcement functions, it is also entitled to carry out prevention functions. I'll speak about this in a bit, but one of its main functions is to receive the communications from public officials, from state institutions, private institutions, from media, complaints from people regarding these corruption violations, and inquire into this information. Based on their inquiry, they make decision whether to launch criminal proceedings or administrative proceedings or disciplinary proceedings, and once they pass this decision, they submit these materials. They relinquish this information, these materials and information to other institutions. So usually if they decide to launch criminal proceedings, they will pass on the case to the Criminal Investigations Department. If they make a decision that the corruption violation is not serious enough in order to merit criminal prosecution, they will launch administrative proceedings or start a civil case and either submit it to court. As you know, according to our administrative legislation, they can either directly appeal to court or to other competent institutions which can make a decision on administrative sanctions. An example, for example, the Prevention and Inquiry Department may look into the case, and in the course of the inquiry they can find out that certain private sector actors, enterprises, were employing people without contract, and as you know, this is a great big violation which is subject to administrative and criminal sanctions. So if it's not that serious, if it's not too serious, then the Anti-Corruption Directorate will file a case to the State Inspection of Labor, and so on and so on. It can also apply directly to the court to start administrative action against, for example, a social security agency or social security public official who violates the requirements of legislation. When it comes to prevention function, this unit is actively employing the means available to the prosecutors, such as motions. So according to the Prosecution Service Act, the prosecutors are allowed to submit motions to public and private institutions and officials, requiring them to eliminate circumstances conducive to corruption. And the recipients of these motions, they have to take on these motions seriously, and they have to look at it, and they have to consider it and report on the implementation. Also, this Prevention and Inquiry Department, it conducts this survey of the institutions where it conducts inquiries, and it kind of tries to discern the trends of corruption existing in these institutions. I mentioned to you earlier the Criminal Investigation Department. It investigates criminal cases and submits to courts. The Internal Security Division is in charge of the information, looking into information coming from law enforcement agencies about the corruption instances in law enforcement agencies, as well as judiciary. It also is in charge of internal security, the protection of the employees of the KMBI, as well as monitoring of their activity, securing that they are behaving in a proper way and don't break these legislative requirements. They are closely cooperating with the operational intelligence, the detection department. But before mentioning them, these last two, I will mention the specialist division. Specialist division is composed of in-house specialists. These are the specialists in various fields. They're not lawyers. They're specialists in the field of taxation, banking, municipal affairs, social security, and so on. So these people, they're actually helping, providing this expertise to the investigators and inquirers in the course of their activity. And of course, their work cannot be used as a direct evidence in court, but their help is crucial in investigating corruption practices. The final two are operational intelligence, i.e. detection department, and the division which technically supports this, the work of this department. They're composed mostly of detectives. These are kind of like for simple understanding, these are like police officers, but operating under the umbrella of the prosecutors. They are actually going into the fields, collecting intelligence activity. Their work is subject to the regulation by the Prosecution Service Act, as well as the Operation Detection Act, which is the terminology used for the special investigation means. If you don't understand special investigation means, I can give you an example. It's where these people behind the scene, they wiretap your phones, they're following you secretly. So there are types of different sorts of activities conducted in a secret and non-secret way, whereby they collect information, intelligence, and they if there's enough information, they will proceed to pass it on to the investigators and prosecutors. When I said to you about this independence in the context of KMBI, it's more appropriately described as an autonomy, I would say. First of all, Anti-Corruption Directorate is a prosecution service, autonomous prosecution service, and prosecution service in Azerbaijan is a part of the judicial branch of power. It's not an executive. Prosecution service in Azerbaijan is a constitutional body, as you know. The prosecutor general is elected through this procedure involving parliament and the president. And the head of the KMBI is appointed and released from his position by the released from his position by the President of the Republic of Azerbaijan. And this is one of the means to secure the autonomy. Then, as I told you, it's provided in the statute of the Prosecution Service Act that the Anti-Corruption Directorate is a specialized autonomous prosecution service. And importantly also, it's important to mention here that Anti-Corruption Directorate has a procedural independence. What that means is that it is the director of the KMBI who is actually conducting the procedural management of criminal investigation and inquiries, as well as intelligence in the KMBI. He is endorsing the Indictment Act, which is the document necessary to submit the criminal case to court. It's him and not the Prosecutor General who does that. Of course, within the system of the prosecution service, the Prosecutor General can quash the decisions of the director of the KMBI, but this has to be substantiated and a kind of exception and not as a rule. In terms of maintenance, KMBI has its proper staff policy. It's fully staffed with the prosecutors, investigators, detectives, specialist technicians. It has good logistics. It has a good premise, transportation, up-to-date IT, communication equipment, and it has good tools for capacity building, such as training at local and international level and development of investigation techniques. Here in the picture you can see the staff of the directorate with the president of the country. It's also important to mention that KMBA is operating a hotline, Special Anti-Corruption Hotline 161. It was established on the 3rd of March 2011 by the decree of the Prosecutor General. It operates 24/7 without holidays, throughout the day, without weekends. It's free of charge, and it gives the possibility to apply the directly to the ACD by persons affected by corruption. You'll see subsequently in the statistics that many cases originated in the ACD specifically from this hotline. If you look at the statistics, and for facilitation of your comprehension, I provided it in also in Azerbaijani language. It is a number of cases submitted to court, number of corruption cases, because whether we want it or not, we recognize it or not, but the fact is that the people usually measure the efficiency of the anti-corruption efforts and activities by the number of criminal cases, i.e. by the spilled blood of corruptioners. So you can see that the number is steadily growing. Here in the first row we have the number of people subject to the arrest. So if you look here, it's in 2007 only 16 persons were arrested, while the number grows. In 2015 it was 76 people arrested. Here you, in the second row, you see the number of the indicted people, indicted persons, defendants in the criminal cases. In 2007 it started with 69, gradually growing and reaching 295. I should say that in last year, in 2019, it was over 400, and the number of criminal cases, starting with 41 in 2007, raised up to 200 in 2015, and last year it was just close to 300. Here you can see I brought this for you to see the results of the work in terms of the recovery of the ill-gotten assets by the corrupted officials. Here you also see the steady growth of numbers from 2006 to 2015. It raised from 295,000 manats to up to 36 million manats in 2015. If you're interested in what kind of cases there were investigated, the ACD investigated throughout these years, here you have the case of bribery. In 2005 it was 21, raising up to 59 in 2009, and going gradually back to 2015. Embezzlement, it went up to 41 in 2014, then it's 35. Now I should say that, and as you see, fraud was 66. Proportionally, the proportion of cases by categories is the same in the last year. The numbers have grown substantially in there if you look at the statistics of 2019. Here are the numbers, the statistics about the detective activities, special investigation means. They started after these units, this function was vested, commissioned with Anti-Corruption Directorate in 2011. It started with the modest number of 77 and it raised to 419, and it even round in the somewhere in the area of 1000 now. Here you can see the number of information which they received and reviewed from the hotline, directly from hotline. Here's the number from of information received from citizens which they took into account and start checking. And here are the number of the special operations which were conducted in years 2011 to 2015. In 2015 it was 14. When we speak about so far we spoke about the specialized anti-corruption agencies in a narrow sense, and I also mentioned to you that we can speak about them in a wider circle, wider sense. In that sense, I mentioned to you the activity of the Asan service. Asan service is a champion in this field. It is operating under the State Agency for Public Service and Social Innovations. Under the President of the Republic of Azerbaijan, it was established by the presidential decree in 2012. Again, you don't have to remember this date or the number. Essentially, Asan is a one-stop shop. Sorry, I put here show, but it's shop actually. Also, in the international terminology, we call it one-window shop. The idea is that it brings together the representatives of public institutions, government institutions. Here in Asan, it's 10 government entities and private companies. So the state agencies, they commission, they second their employees as well as their information framework, their information infrastructure, their databases access to the special centers of delivery of public services. So when you go there, you would see that there are separate sections for the Ministry of Justice employees, Ministry of Internal Service, Internal Affairs employees, and so on and so on. And it provides this public service under this umbrella of Asan, which secures the high level of the rendered services, the high level of provided work. Currently, as you see here, a number of services here, such as issuance and renewal of passport of citizens, or registration of commercial and legal persons and taxpayers. There are 300 services. Key principles of Asan are efficiency, transparency, comfort, politeness, innovativeness. Asan in the recent years, Asan was initially planned by the government as an institution which will bring transparency to the public service in Azerbaijan. Indeed, it brought transparency to public service, but it also dramatically raised the quality of these public services, public civil service of the people who work in public service. Asan service affected dramatically the anti-corruption efforts in Azerbaijan. We can confidently state that the level of corruption, visible corruption in Azerbaijan, it dropped dramatically. The petty corruption was wiped off from the public institutions. We can say that with confidence. Um, People now cannot imagine, for example, paying for passports or national IDs, while this was quite widespread in the preceding years. Asan also became an alternative for corrupted institutions. So we know the famous cases when, for example, I keep saying this, for example, word quite frequently, apologies for that, when the transport ministry, which was scrapped by the government, when due to these irregularities and poor operation, its functions were passed on to Asan, and Asan took on its functions in a very professional way, in a very efficient way. So Asan became a kind of etalon of delivering of public services, and from this point on, Asan started to develop criteria and indicators for the efficiency of public institutions. So it developed its own Asan indicators, and state institutions are actually evaluated according to the criteria of these Asan indicators. And the best indicator of the efficiency and hard work and good work rendered of Asan delivered to the population is that within its 7 years of its operation, 35 million people visited its centers. Well, the population of Azerbaijan, as you know, is 10 million. So when we look at these specialized agencies, we mention here the Commission on Combating Corruption, CCC, the KMBI Anti-Corruption Directorate with the Prosecutor General, Asan, and the Asan-type agencies such as DOST, which is operating under the Ministry of Labor and Social Security, the Civil Service Authority, which I wanted to mention to you very briefly. A Civil Service Commission under the President of the Republic of Azerbaijan used to exist until recently. It conducted an excellent work of building civil service standards in the field of recruitment, promotion, and disciplining and enticing of civil servants as a result of the efforts of this authority, of this institution, which formerly used to be a commission. Now it's a part of the State Examination Center. It established a system of licensing of civil service, whereby people actually apply, pass the examination, and they get their license to become civil servants as a result of this initial examination which they pass, and then they apply with this license for the vacant positions in ministries and other institutions, and they pass this competition in order to occupy civil service positions. So this was a crucial effort in order to suppress corruption in Azerbaijan. Finally, internal units, as I mentioned, they were established in accordance with the state anti-corruption strategy, that each state institution has to establish its internal unit. The idea behind it is that previously before the independence time, there was one institution which looked at the internal security, at the suppression of corruption in all state institutions, and then with the course of time this function was decentralized. So each state institution was vested with its own anti-corruption efforts, developing of its own strategy, and as well as looking into the complaints of the citizens. This doesn't mean that the citizens cannot complain. Otherwise, they always can complain to the law enforcement agencies and courts, but If the citizens, the people, if they prefer, they can comply about the corruption practices in that institution to the very institution itself, and in that case, that complaint will be considered by the internal unit, which will make an inquiry, and upon this inquiry, it will make a decision whether to launch a disciplinary provision or further recommend the head of the institution to relinquish this information to the law enforcement agencies. These internal units, they can operate on their sui generis base, on their own initiative, and they can actually carry out these inquiries on their own initiatives about the irregular behavior of their staff. That is the end of our lecture. I hope you understood, you grasped the basic concepts of specialized anti-corruption institutions. Thank you for your attention.